Hello, everyone, and welcome to the American Association of University Women's United States Supreme Court wrap-up call for the October 2016 Supreme Court term. I am Ebonee Avery-Washington, Program Manager for the Legal Advocacy Fund, and I will be hosting this call. We will be reviewing 4 of the 62 cases that the Supreme Court decided this term. I enjoyed my preparation for this call, and I hope that you enjoy this review. In law school, we learn how to brief a case by using the FRAC method. Fracking a case is identifying the facts, rule, analysis, and conclusion. Sometimes this process includes the issue. I will follow the FRAC method of review during our discussion. So those on the call that have not been legally trained can now say they spent a little time in law school, minus the money, time, and stress. This call will last approximately an hour. You can feel free to follow along with the material you were emailed prior to the call. The material contains the facts, substantive or relevant law of the case, and the conclusion reached by the Supreme Court. I will not be taking questions during the call, but if you have a question after the call, you can feel free to email me at laf@aauw.org, and I will answer your questions. I will take brief transition breaks between the cases. During the breaks, I will answer your previously submitted questions, give you time to respond to my inquiries, or email me. Again, my email address is laf@aauw.org. Some of the cases we will discuss were reached by 8 justices, and some by a full 9 justices, with the addition of Justice Gorsuch. It is important to note that AAUW opposed Justice Gorsuch's confirmation. We did not come to this decision lightly. AAUW believes that, as with all nominations, a full and fair vetting process is vital to determine the nominee's qualifications, record, and temperament. After careful review of Justice Gorsuch's record, including his 10 years of appellate opinions and his testimony to the Senate Judiciary Committee, we found him to be a troubling choice. As you know, for well over a century, AAUW has influenced legislative debate on critical issues affecting women and girls. We also have a long-standing policy of being nonpartisan. These 2 traditions are not contradictory. While AAUW's nonpartisan policy means that AAUW does not endorse party-nominated candidates, we do take firm positions on policies, nominees, and legislation that affects women. Regarding Justice Gorsuch, we felt it was necessary to take a stand because the Supreme Court decisions have tremendous significance for all of us on a macro and micro level. I would like to share a quote with you from Justice Sonia Sotomayor. Hopefully some of you on this call got a chance to meet her at our national convention a few weeks ago. She says, "I strive never to forget the real-world consequences of my decisions on individuals, businesses, and government." For me, this quote works twofold. The Supreme Court establishes the law of the land, and so we are all impacted by its decisions. But let's also remember that there are people at the heart of these cases with real and genuine grievances. With that in mind, let's get started with our first case. Our first case for this evening will be the Trinity Lutheran Church of Columbia v. Comer. This case involves a church, a daycare with a playground, a government program, and the First Amendment. That's quite a combination. The Trinity case is one of the cases that garnered a lot of attention this term. You might have heard your respective communities discuss a playground case. The case was argued before the Supreme Court on April 19, 2017, and decided on June 26, 2017. The facts of the case are as follows. Trinity Lutheran Church Learning Center is a Missouri preschool and daycare center. The center, which was established as a nonprofit, merged with Trinity Lutheran Church. The center is located on church property and has a playground largely covered in pea gravel under the play equipment. The state of Missouri has a scrap tire program, which is run by the state's Department of Natural Resources. The scrap tire program offers reimbursement grants to qualifying nonprofit organizations that install playground services made from recycled tires. Now, if you're a mom or a sister or a grandma that frequents the playground, you know the current trend in playgrounds is rubber or flexible surfaces, which is far less harsh than the pea gravel I grew up with, and I have the bruised knees to prove it. In 2012, the center applied to the program to replace a large portion of the pea gravel and with pour-in place rubber. Although the center ranked 5th in priority out of 44 applicants, it was denied the grant because the center is owned by a church and the department has a strict and express policy of denying grants to any applicants owned or controlled by a church, sect, or other religious entity. Let's follow this case along its judicial journey. The Trinity Lutheran sued in federal district court, alleging that the department's failure to approve its application violated the free exercise clause of the First Amendment. The district court dismissed the suit, holding that the free exercise clause did not require the state to make funds available under the scrap tire program to Trinity Lutheran. A divided panel of the Eighth Circuit affirmed the fact that the state could award a scrap tire grant to Trinity Lutheran without running afoul of the Establishment Clause of the federal Constitution. Rehearing en bloc with the full panel was denied by an equally divided court. The Supreme Court reversed, holding that the Missouri Department of Natural Resources express policy of denying grants to any applicant owned or controlled by a church, sect, or other religious entity violated the rights of Trinity Lutheran Church of Columbia under the Free Exercise Clause of the First Amendment by denying the church an otherwise available public benefit on account of its religious status. Let's take a look at the laws and analysis that brought the Supreme Court to this conclusion. To summarize the legal issue, this case asks, should a daycare center owned by and operated within a church be able to apply for and receive a state government grant to make improvements to the daycare? The rule. Answering this question involves an analysis of the First Amendment, which says, Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof. The last three words, free exercise thereof, is known as the Free Exercise Clause, which generally allows an individual to be secure in the freedom to exercise or practice the benefits or traditions of a religion. The state, in this case Missouri, cannot hamper its citizens in the free exercise of their own religion. Analysis. The Supreme Court's opinion discussed three major points in arriving at the conclusion that the state's Department of Natural Resources denial of the center's application was a violation of the Free Exercise Clause. The first, In general, the Supreme Court has held that denying a generally available benefit solely for religious identity imposes a penalty on the free exercise of religion. The opinion of the case cites McDaniel v. Patty. In the McDaniel case, the court struck down a Tennessee statute that did not allow a minister to serve as delegates in the state's constitutional convention. The Tennessee statute was construed to force individuals to make a choice, either this or that. Within the McDaniel case, a minister would have to stop being a minister to participate as a delegate. To pursue one, he would have to give up the other, which infringes on his civil liberties. The court interprets this as imposing a restriction on religious exercise. The Free Exercise Clause protects against laws that impose special disabilities on the basis of religious status. In its analysis, the court drew an analogy with the Trinity case: participate in an otherwise available benefit program or remain a religious institution, this or that. Missouri asserted that the state has no obligation to provide a benefit, grant, or subsidy, so declining to confer a benefit does not burden the church's free exercise of rights in a meaningful way. But the court reasoned that the discrimination against religious exercise here is not the denial of a grant, but rather the refusal to allow the church, solely because it is a church, to compete with secular organizations for a grant. Following established precedent, the Supreme Court reasoned that Trinity Lutheran is not claiming any entitlement to a subsidy, but it is asserting the right to participate in a government benefit program without having to disavow its religious character. The second, and far shorter point, is that the condition of having to disavow one's religious character to compete for a benefit imposes a special disability on the basis of religious status, which triggers the strictest scrutiny. The third point is, finally, the court found that the department's discrimination policy does not survive the most rigorous scrutiny, often referred to as strict scrutiny. In order for a law to be found constitutional using this standard, the state must demonstrate that the state's interest is of the highest order to justify the policy at issue. The state must prove that the law is necessary to meet a compelling state interest. The key words there are necessary and compelling. That is a very high bar to meet. In the Trinity case, the court found that the department's policy was not able to pass this most rigorous scrutiny. Conclusion. The court concluded that the Missouri Department of Natural Resources policy violated the rights of Trinity Lutheran under the Free Exercise Clause of the First Amendment by denying the church an otherwise available public benefit on account of its religious status. Let's take a roll call to see how the justices voted on this case. Chief Justice Roberts delivered the opinion of the court, except as to footnote 3. Justices Kennedy, Alito, and Kagan joined the opinion in full, and Justice Thomas and Gorsuch joined except as to footnote 3. Justice Thomas filed an opinion concurring in part in which Justice Gorsuch joined. Then Justice Gorsuch filed an opinion concurring in part in which Justice Thomas joined. Justice Breyer filed an opinion concurring, and Justice Sotomayor filed a dissenting opinion in which Justice Ginsburg joined. There was some discussion there about footnote 3. Footnote 3 in the opinion reads as follows. This case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination. And that was footnote 3. I did receive a question via email about this case, and I appreciate the question. Thank you. The question was, what effect did the governor of Missouri's announcement have on this case, and why did the Supreme Court still hear the case? So I want to give you a little bit of background before I answer the question, or in answering the question. In April of 2017, the governor of Missouri made an announcement that directed the department to begin allowing religious organizations to compete for and receive department grants on the same terms as secular organizations. So you would think that that would prevent the Supreme Court from hearing the case, or that would resolve the issue. There was actually some discussion about this within the opinion of the case. There was discussion as to whether that announcement made the case moot. Moot is defined as an issue that remains unsettled, open to argument, or debatable. This is relevant because the Supreme Court only decides actual controversies and would not hear a moot case. However, the Supreme Court has established that when a voluntary cessation of a challenged practice does not moot a case unless subsequent events make it absolutely clear that the alleged wrongful behavior would not reasonably be expected to reoccur. In this instance, the Supreme Court didn't have assurances that the behavior would cease, so they decided to hear the case and render a decision. If you're a Missouri resident, or this case is of particular interest to you, I would love to know how you feel about this case. So please share your thoughts when you have a moment by emailing me at laf@aauw.org. And now we'll get ready to transition to our second case for the evening. Our second case is McLean Company, Inc. v. the Equal Employment Opportunity Commission. This case was argued February 21st, 2017, and decided April 3rd, 2017. Unlike the Trinity case, you didn't hear a lot about this case. Not many people are discussing this one, but I wanted to include this case because the actual facts buried underneath the legalese deal with the scope of legal issues within the purview of the Legal Advocacy Fund, specifically Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination on the basis of race, color, religion, sex, or national origin. By statute, the Equal Employment Opportunity Commission, or EEOC, enforces this provision. For many LAF plaintiffs supported through our legal case support program, the EEOC provides process, and in some cases, it's the first step in obtaining justice for our LAF plaintiffs. The EEOC does an initial investigation when it receives a claim of discrimination based on race, color, religion, sex, or national origin. This case is about one of the tools that the EEOC has at its disposal in conducting its investigation, a subpoena, which can give broad access to relevant information. An employer may petition the EEOC to revoke the subpoena, but if the EEOC rejects the petition and the employer still refuses to obey the subpoena, the EEOC may ask a district court to issue an order enforcing it. Now that we have established a framework, let's look at the facts. And I will use the opinion's resuscitation of the facts. The opinion states Demina Ochoa worked for 8 years in a physically demanding job for petitioner McLean Company, a supply chain service company. McLean requires employees in these positions, both new and those returning from medical leave, to take a physical evaluation. When Ochoa returned from 3 months of maternity leave, she failed the evaluation. She failed it a total of 3 times and was ultimately fired. She then filed a sex discrimination charge under Title VII of the Civil Rights Act of 1964. The EEOC began an investigation, but McLean declined its request for so-called pedigree information, which included names, Social Security numbers, addresses, and telephone numbers of employees asked to take the evaluation. After the EEOC expanded the investigation scope, both geographically to cover McLean's national operations and subjectively to investigate possible age discrimination, it issued subpoenas. McLean refused to provide the information. That started this case's judicial journey, which is actually essential to this case. The EEOC filed 2 actions to enforce the subpoenas in federal district court, one for Ochoa's charge of discrimination based on sex, and the other for the EEOC charge of age discrimination. The district judge declined to enforce the subpoenas, finding that the pedigree information was not relevant, but the Ninth Circuit reversed. The Ninth Circuit reviewed the district court's decision to quash the subpoena using a de novo standard of review. The court concluded that the pedigree information was relevant, which brings us to the reason why this case has not garnered a lot of media attention. The issue presented turns on a technical analysis of the appropriate standard of review. The Supreme Court must determine whether the decision to enforce or quash an EEOC subpoena should be reviewed using the abuse of discretion or de novo standard of review. Standard of review is a legal term of art. It is the legal lens in which the question presented must be decided. The de novo standard used by appellate courts allows for a new look or fresh look at the issue, while abuse of discretion determines whether the adjudicator has failed to exercise sound, reasonable, and legal decision-making. In analyzing this issue, the court finds 2 main points persuasive. The first is history, and the second is that the lower court's ability to exercise discretion in discerning if information requested within a subpoena is relevant. Today, almost every court of appeals uses the abuse of discretion standard. While the numbers are persuasive, what seemed most important to the court was the long history of using the abuse of discretion standard within appellate practice. Justice Sotomayor wrote in the opinion, the district court's decision whether to enforce a subpoena will turn either on whether the evidence sought is relevant to the specific charge before it, or whether the subpoena is unduly burdensome in light of the circumstances. Both tasks are well suited to a district judge's expertise. I believe she is saying that since the district judges are well suited to make these determinations, a fresh look or a new look, meaning a de novo look, is not necessary. The remaining reasoning within the brief addressed, then dismissed, amici claims that the standard should be de novo. Conclusion. The court concluded that a district court's decision to enforce an EEOC subpoena should be reviewed for abuse of discretion and not de novo. Let's take a look at how the justices decided this case. Justice Sotomayor delivered the opinion of the court in which Chief Justice Roberts, Justices Kennedy, Thomas, Breyer, Alito, and Kagan joined. Justice Ginsburg filed an opinion concurring in part and dissenting in part. So what happened to Mrs. Ochoa? Well, we don't know yet. The judgment of the Court of Appeals was vacated, and this case was remanded back to the lower courts for further proceedings. Let's take a brief moment while we transition to our next case. Our third case for the evening is Miguel Angel Pena Rodriguez v. Colorado. This case allows us to take a look at the importance of the jury and the role it plays within our judicial system. The opinion of this case, written by Justice Kennedy, states that the jury is a necessary check on government power and a tangible, intimate implementation of the principle that the law comes from the people and is a safeguard of individual liberty. If a jury is charged with safeguarding individual liberty, what happens when a juror is motivated by bias? How is liberty impacted then? Let's look at the facts. Miguel Angel Pena Rodriguez was prosecuted by Colorado based on allegations taking place in 2007. Two teenage sisters accused the man of sexually assaulting them in the bathroom of a Colorado racehorsing facility. Each girl separately identified Miguel Angel Pena Rodriguez. Pena Rodriguez was ultimately found guilty of unlawful sexual contact and harassment, but the jury failed to reach a verdict on the attempted sexual assault charge. After the jury was discharged, Pena Rodriguez's attorney entered the jury room to discuss the trial with the jurors. After discussion, two jurors lingered to speak with the attorney in private. During that conversation, they disclosed that another juror expressed anti-Hispanic sentiments during deliberation. The juror, identified as H.C., made the following statements. He believed the defendant was guilty because, in H.C.'s experience as an ex-law enforcement officer, Mexican men had a bravado that caused them to believe they could do whatever they wanted with women. I think he did it because he's Mexican, and Mexican men take what they want. H.C. further explained that, in his experience, 9 times out of 10, Mexican men were guilty of being aggressive towards women and young girls. The jurors also recounted that H.C. said he didn't find petitioner's alibi witness credible because, among other things, the witness was an illegal. In fact, the witness testified during trial that he was a legal resident of the United States. Pena Rodriguez's attorney then filed a motion for a new trial. The motion was denied, although the court acknowledged H.C.'s bias. Judicial journey. The court acknowledged H.C.'s apparent bias, but denied petitioner's motion for a new trial on the grounds that Colorado Rule of Evidence generally prohibits a juror from testifying about statements made during deliberations in a proceeding inquiring into the validity of the verdict. The Colorado Court of Appeals affirmed, agreeing that H.C.'s alleged statements did not fall into an exception of Rule 606B. The Colorado Supreme Court also affirmed. The Supreme Court then had to determine if the Constitution requires an exception to the no impeachment rule when a juror's statements indicate the racial animus was a significant motivating factor in his or her finding of guilt. The rule. In order to answer this question, we must define the no impeachment rule. The no impeachment rule was established at common law and has evolved. It is intended to assure jurors that once their verdict has been entered, it will not be called into question based on comments or conclusions they expressed during deliberations. The rule seeks to give stability and finality to verdicts. In 1975, Congress adopted the Federal Rules of Evidence and endorsed a broad no impeachment rule with only limited exceptions. It is important to note that the Colorado rule mirrors the federal rule. The current version of the rule, 606B, states as follows. 1. Prohibited testimony or other evidence. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury deliberations. The effect of anything on that juror's or another juror's vote, or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statement on these matters. 2. Exceptions. A juror may testify about whether A. Extraneous prejudicial information was improperly brought to the jury's attention. B. An outside influence was improperly brought to bear on any juror. Or C. A mistake was made in entering the verdict on the verdict form. So as you can see, there are exceptions, but none for racial bias. Your state has a non-impeachment rule, as every state and the District of Columbia has some version of the rule on the books. According to the opinion of the court, 16 states have established an exception for juror statements illustrating racial bias in deliberation, and 3 federal courts have made a racial bias exception. The court goes on to point out ambiguities and nonconformity in application, with exceptions for racial bias from jurisdiction to jurisdiction, which makes this case appropriate for the Supreme Court to establish precedent given the ambiguity. Analysis. Historically, an exception has only been considered in the gravest and most important cases, as established by United States v. Reed. The court states that racial animus implicates unique historical, constitutional, and institutional concerns, and if left unaddressed, would risk systemic injury to the administration of justice. As a proponent for social justice, I was uplifted by this opinion because the court identifies the necessity of moving beyond racial animus in the judicial system. The opinion referenced the history of racially motivated outcomes within the justice system. It cites, by example, the fact that between the years 1865 and 1866, all white juries in Texas decided a total of 500 prosecutions of white defendants charged with killing African Americans. All 500 white defendants were acquitted. One could safely assume that those were racially motivated outcomes. The court draws distinctions from previous cases where the no impeachment rule was upheld in the face of bias, and indicates that racial bias is different in that the existing safeguards might not prove effective to identify and expel racial bias from the jury. In the first case, the court cites Tanner v. U.S., in which evidence revealed that some jurors were under the influence of drugs and alcohol during the trial. In the second case, Warger v. Shower, evidence indicated that the jury forewoman failed to disclose a pro-defendant bias. In both instances, the court relied on existing safeguards. Safeguards like voir dire, the process through which potential jurors are questioned by either the judge or a lawyer to determine their suitability for jury service. Voir dire at the outset of trial, observations of juror demeanor and conduct during trial, juror reports before the verdict, and non-juror evidence after trial are important mechanisms for discovering bias. Yet their operation may be compromised or may prove insufficient in the face of racial animus. The court then notes the somewhat comical common sense of this dilemma. Now, I'm going to take a few liberties here, but I need you to picture this with me. A potential juror sitting there with the judge, counsel, and their neighbors looking at her is asked, "Are you a bigot?" What is the likelihood that she will answer, "Yes, I'm a bigot"? In the alternative, if she is a bigot, she might be compelled to give a socially acceptable answer. And now we have just unwittingly let a bigot onto the jury. Of course, that scenario was not in the court's opinion. That was just what I pictured in my mind as the court was discussing how the existing safeguards of voir dire might be insufficient in the face of racial bias. Conclusion. For the reasons we just discussed, the court held that where a juror makes a clear statement that indicates he or she relied on racial stereotypes or animus to convict a criminal defendant, the Sixth Amendment requires that the no impeachment rule give way in order to permit the trial court to consider the evidence of the juror's statement and any resulting denial of the trial guarantees. Let's take a roll call on how our justices decided. Justice Kennedy delivered the opinion of the court, in which Ginsburg, Breyer, Sotomayor, and Kagan joined. Justice Thomas filed a dissenting opinion. Justice Alito filed a dissenting opinion in which Chief Justice Roberts and Thomas joined. I also received a question about this case, and I'm going to read that question. The question was, do racist statements like this automatically result in a new trial? Thank you so much for the question. No, the answer is not automatically. I should note that the opinion of the court indicated that not every offhand comment indicating racial bias will trigger this exception to the no impeachment rule. And the court actually placed a substantial amount of discretion on the lower courts in establishing how they should proceed if the exception is triggered. That might result in the verdict being set aside, or that might result in a new trial. The court left it up to the lower court's discretion. So again, thank you so much for that question. As we transition to the next case, let's consider the two jurors brave enough to share what they heard HC say. Would you be that brave? If you were asked to serve on a jury, selected, and overheard a fellow juror espousing a bias based on sex, would you report his or her statements? Take a moment to think about that and email me your thoughts when you have time. Again, my email address is laf@aauw.org. And now we'll transition to the last case. Our last case this evening is Jefferson V. Sessions III, Attorney General, v. Luis Ramon Morales Santana. This case was argued November 9th, 2016, decided June 12th, 2017. This case confronts a gender-based difference in transferring citizenship pursuant to the Immigration and Nationalization Act, or to state it as plainly as Justice Ginsburg, gender discrimination. That's what we're talking about in this case. Facts. Luis Ramon Morales Santana has lived in the United States since he was 13. He asserted U.S. citizenship at birth based on the U.S. citizenship of his biological father, Jose Morales. Jose Morales moved to the Dominican Republic 20 days short of his 19th birthday, therefore failing to satisfy the requirements established to pass citizenship to his son through the Immigration and Nationalization Act. In the Dominican Republic, he lived with the Dominican woman who eventually became his wife, who gave birth to Morales Santana. Jose Morales accepted paternal responsibility of Morales Santana and was eventually listed on his son's birth certificate. In 2000, the U.S. government tried to remove Morales Santana based on several criminal convictions categorizing him as an alien because at his time of birth, his father did not satisfy the physical presence requirement. An immigration judge rejected Morales-Santana's citizenship claim and ordered his removal. Morales-Santana later moved to reopen the proceedings, asserting that the U.S. government's refusal to recognize that he derived citizenship from his U.S. citizen father violated the Constitution's equal protection guarantee. Rule. The relevant rule of law in this case is the Immigration and Nationalization Act, or INA. Chapter 1, Title 3, Section 1401, which establishes who shall be nationals and citizens of the United States at birth. I identified the Equal Protection Clause as the substantive law within your materials because Morales-Santana is petitioning the court on equal protection grounds. However, Section 1409 is our relevant law. Section 1409A pertains to children born to unwed parents. And during the time the facts arose, it mandated an unwed citizen to be physically present in the United States for 10 years, 5 of which had to take place after the 14th birthday of that citizen in order to transmit U.S. citizenship to a foreign-born child. At this point, I know you're thinking, when is she going to get to the gender discrimination? Well, here it is. Section 1409C is a provision applicable only to unwed U.S. citizen mothers. Subsection C creates an exception to the physical presence requirement only for unwed citizen mothers. This gender exception allows the unwed citizen mother to have only 1 year of continuous physical presence within the United States prior to the birth of her foreign-born child to pass citizenship to said child. Jose Morales, the father, was born in Puerto Rico, which is, as we know, is part of the United States. He was Morales-Santana's citizen parent, but he is not able to pass citizenship to his son because although he physically resided within the United States for almost 19 years, 5 of those 19 years were not after his 14th birthday as prescribed by law. He fell only 20 days short of meeting this goal. If he had been an unwed citizen mother, however, he would only have had to be physically present in the United States for 1 year prior to the birth of his son to pass citizenship. That is discrimination based on sex. The court is allowing Morales-Santana to take the unique step of asserting the constitutional claim of another, in this case, his father. He is asserting that his father was discriminated against because of sex. He is permitted to petition his father's claim because as father and son, they are in close relationship, and there is a hindrance to his father pursuing his own claim because his father has died. Both the close relationship and hindrance element are required by law to bring the constitutional claim of another. Analysis. This opinion, written by Justice Ginsburg, gives us context to our nation's legal history as it relates to gender classification discrimination. Precedents were established that allowed states to draw a sharp line between the sexes. Today, laws that make these distinctions are reviewed with heightened scrutiny. The appropriate standard of review is sometimes called intermediate scrutiny. The government must show, at least, that the classification serves an important government objective and that the discriminatory means employed are substantially related to the underlying interest. The court, in its opinion, concluded that the government did not identify a specific interest. In the absence of an identified interest, Justice Ginsburg offers more context, stating that our nation's citizenship laws were established with the following assumptions. In marriage, husband is dominant, wife subordinate. Unwed mothers are the natural and sole guardians of a non-marital child. Wow, that was a mouthful. Now, what does all this have to do with difference in physical presence requirements between unwed citizen mothers and unwed citizen fathers? The government argued that gender differential ensures that a child born abroad has a connection to the United States of sufficient strength to warrant passing citizenship at birth. To summarize the government's argument, a mother is naturally first on the scene or present in a child's life, naturally. The father is second. Therefore, a mother's influence is great. Looking at this from the perspective of an unwed, non-citizen mother, the government asserts an unwed citizen father will have to have a longer physical presence in the United States to combat the great influence of the child's non-citizen mother. Now change perspective. The government also relies on the assumption that an unwed non-citizen father is far less likely to be a part of the child's life. So given that assumption, the unwed citizen mother does not need to have spent so much time physically present within the United States because of her great influence. And finally, the government contends that the gender differential was established to combat the statelessness of the child, which arises when foreign-born children are not able to claim any citizenship because of the constructs of the laws in the countries in which they were born. The court asserts that none of these jurisdictions overcome intermediate scrutiny. None of these justifications overcome intermediate scrutiny. That is, are substantially related to serve an important government interest. Therefore, the gender line that Congress drew is incompatible with the Fifth Amendment's requirement that the government accord to all persons the equal protection of the laws. However, that's not the end of our analysis. Within this case, you can see the interplay of two of our three branches of government, the legislature and the judiciary, Congress and the courts. The court has made a judicial determination, but Congress is left to amend the law because the court is not equipped to grant relief to Morales-Santana seeks. The court relies heavily on a case titled Welsh v. United States, which established two remedial alternatives. When a statute benefits one class, in this case unwed mothers and their children, and excludes another from the benefit, here unwed fathers and their children, the two alternatives are to nullify the protection to the benefited class or to extend the benefit to the excluded class. Precedent establishes that this determination is made by measuring the intensity of commitment to the main rule and considering the degree of potential disruption that would arise by extending the exception. Ultimately, the court reasoned that the potential for disruption in allowing unwed fathers to have the 1-year exception is great and would not likely embody the legislative intent, given the government's notion that physical presence has a strong correlation with citizenship. I will quote excerpts of the opinion for the conclusion of this case. Although extension of benefit is customary in federal benefit cases, all indicators in this case point to the opposite direction. Put to the choice, Congress, we believe, would have abridged 1409C's exception, preferring preservation of the general rule. The gender-based distinction we hold violates the equal protection principle, as the Court of Appeals correctly ruled. Congress may address the issue and settle on a uniform prescription that neither favors nor disadvantages any person on the basis of gender. Let's take a roll call to see how the justices decided. Justice Ginsburg delivered the opinion of the court, in which Chief Justice Roberts, Justices Kennedy, Breyer, Sotomayor, Kagan joined. Justice Thomas filed an opinion concurring in the judgment in part, in which Justice Alito joined. And Justice Gorsuch took no part in the consideration or decision of this case. And that concludes the review of our final case. So we have discussed what happens when a church, a playground, and a government program collide with the First Amendment. We have discovered that when a juror reaches his conclusion by relying on racial animus, an exception can be made to the court to question the jury verdict, and that gender classification discrimination is incompatible with the equal protection guarantees. I hope that you have enjoyed the AAUW's review of the October 2016 term. AAUW's Legal Advocacy Fund will also be hosting a Supreme Court preview call for the court's October 2017 term. If you would like to hear this presentation again or want to share it with others, a recording will be made available online in a few weeks. Again, feel free to email me your questions or comments at laf@aauw.org. My name is Ebonee Avery-Washington, Program Manager for the Legal Advocacy Fund, and I want to thank you for your time and attention. Have a wonderful night.